The discussion of today will be on the Section 189, which is the regulation within the South African Labour Relations Act, where it talks to the engagements of the union as well as the employer. Should the employer contemplate to retrench or to restructure their business? So the various Assistant General Secretaries of Sasbo, they will take us through and let us know what is it all about.
In South Africa, all retrenchments are actually governed by the Labour Relations Act. We also have the privilege to actually refer our matters to Labour Court if we are not happy and we challenge the procedure, as well as we can take it to facilitation by the CCMA, which is the Commission for Conciliation, Mediation and Arbitration. Sasbo has been very fortunate to challenge the procedure, 2 cases of which one has been published.
Sasbo's successes rest on 4 pillars. 1, we apply the law. 2, we question the rationale. 3, we minimize the impact of retrenchments, for example, negotiating a reassignment period or a buffer period. 4, we enable reskilling prior to retrenchments, or as a last resort, enable a second career.
We've had in recent times 2 substantial restructuring exercises. The one was for 1,260 people and the other one for 760. We go through a comprehensive consultation process where we interrogate the business rationale of the bank, and that often leads to a lot of people being taken off the retrenchment list. In addition to that, we have a reassignment period of 3 months prior to termination, in terms of which people are placed in other vacancies in the bank. We also have a great retrenchment package that is on offer on a voluntary basis that is 300% more than what the Basic Conditions of Employment Act prescribes.
The COVID-19 pandemic couldn't have come at a worse time in 2020 for the workers of this country. Sasbo members, were not immune to this carnage as well, where we saw 4 of these financial institutions served notices on Sasbo where they were contemplating retrenchments. The biggest of these was that in African Bank, where 1/3 of its workforce was affected. Through CCMA facilitated robust engagements, we had 0 forced retrenchments, something that Sasbo is quite proud to have achieved throughout these engagements.
Bank, about 3 years ago, we had a situation where more than 100 branches closed, and overnight about 1,700 people's positions became redundant. But because of the arrangements and self-selection that we had in place, all the agreements with the bank, at the end only about 81 staff members were retrenched. So that was a significant win for us to have so many people elect self-selection, to leave on a voluntary basis, and everybody still made use of the bank's training initiative that was available.
Is opposing any form of dismissal, including retrenchment. However, when we are faced with retrenchment, we consult with the employer to ensure that a proper and a fair procedure is being followed. We were issued with Section 189 in respect to Mudipane and Fori, and the bank was found wanting.
As in the last year, had to face an unprecedented number of restructurings involving retrenchments of members in the South African financial services industry. The trend from employers is to present Sasbo with business cases in which decisions have already been taken and where they expect consultation around the consequences of those decisions. Sasbo has vigorously opposed any retrenchments of its members, and where members have been retrenched, Sasbo has ensured that they get the best severance benefits possible and that they exit with dignity.
SBB, there were 852 employees affected. Sasbo invoked its rights and referred the matter to the CCMA for facilitation. At the end of the process, we successfully reduced the number of forced retrenchments down to 6. In the South African Reserve Bank, we negotiated enhanced severance packages to the value of around 6 weeks per completed year of service.